Democratic Congressman Gerald Nadler of New York is the chairman of the Judiciary Constitution Subcommittee. He thinks the Attorney General is actually not going far enough here and wants investigations of those who okayed these enhanced interrogation techniques in the first place. Good morning, Congressman.
Good morning.
Thank you very much for being here. Your response to that specific point by the Vice President, which is essentially after the DOJ said they could do it, the National Security Council said they could do it, the administration said they could do it, the DOJ reviewed the conduct and said no prosecutions were in order or investigations were in order. Now to turn around and investigate them, his point is good luck finding CIA agents who will obey orders in the future.
Well, I hope we will not find CIA agents in the future who will torture people and break the law. The United States law is very clear. No one may torture anybody. Obeying orders is no excuse, and anyone who gives orders for torture is just as culpable as people who obey those orders.
But they were told it wasn't torture, and they were told by those officials that they could engage in it.
And the question would be whether they reasonably relied on that. If they reasonably relied on something that appeared to them reasonable, then they're fine. But if someone said, go shoot that person and throw his body out the plane, you cannot and it's legal, you cannot reasonably rely on such advice. Now, the law says very clearly that it is the obligation of the Attorney General to investigate, to see whether crimes were committed anytime there was torture under American jurisdiction. He must do that. If he didn't do that, he'd be breaking the law. My criticism of the Attorney General is that he should not limit the investigation to people in the field who may have committed the torture, but to people who may have ordered it, such as the Vice President, for example.
Those who made the decision. You made several points. I want to just round back to a couple of them. First, to follow up on your statement about those who take the orders and who reasonably rely. Understand your analogy about, if you shoot the guy in the airplane, but this is not, no one's alleging that here.
No, no one's alleging that specific.
I mean,
the question,
you're positing that these CIA agents in the field, after being told by Department of Justice attorneys, these CIA agents are not attorneys, but being told by the attorneys that these techniques are okay, that this is not torture, and that it's all right to engage in these, and then being given the go-ahead to do it by their commanders, should second-guess that they, as the agents in the field, should say, I know better than the Department of Justice lawyers?
First of all, if the Department of Justice lawyers give them advice that they are not entitled to rely on, that's illegal advice, and they cannot reasonably rely on that.
How do they know that?
Let me finish. They must second-guess that because the law says they must. Secondly, I'm not positing that they were right or wrong. I'm simply saying that it's the obligation of the Attorney General to initiate an inquiry. And it may be that they'll conclude that these people had every right to rely on reasonable assurances, and maybe they did nothing wrong. As a practical
matter, Congressman, how are these CIA agents in the field going to be second-guessing attorneys who went to law school, who practiced law for many years, who analyzed the case law? Are you really asking, is that really a practical solution to this?
It is very much a practical solution. It's what the law demands. Ronald Reagan signed that law in 1986, I think it was, and it was passed again by Congress in 1996. And it says that it says very specifically that following orders is not an excuse. We established that at Nuremberg, for that matter.
Not orders, but legal advice. Legal advice from the Department of Justice.
They are entitled to rely on legal advice so long as, in the objective circumstances, that advice was reasonable. And it may be that it was, and that they were fine. But the Attorney General has an obligation under our law to initiate an inquiry to look at that, and that's all we're saying that he should do and is doing.
Now, just to pick up on your other point about, the Department of Justice and this investigation, this, as you know, and as our viewers probably remember, 5 years ago, there was an investigation by the Department of Justice into this CIA Inspector General report. And the Department of Justice then concluded that no investigations were warranted. The evidence wasn't there. It was not to be done. It didn't make any legal sense. The fodder wasn't there. That decision was made by career prosecutors at the DOJ, not political appointees. One of the points Vice President Cheney made was that to now reverse that, to have a political appointee, Eric Holder, come in and reverse the decision by career prosecutors will really undermine the confidence of any government official on what he or she can do.
First of all, Eric Holder is not making any decisions. He has asked a career prosecutor, Mr. Durham, I think his name is, a very conservative Republican career prosecutor, by the way, to investigate and make those decisions. He simply initiated an investigation. He's not making those decisions. It would be improper for any political person to make those decisions.
But it happened 5 years ago. The career appointees said no investigations are warranted.
Well, I'm not familiar with that investigation 5 years ago, but I think we know a lot more now.
You're not?
No, I'm not.
Sir, this is important. This is important. There was an investigation by a task force. Well, let me just educate you. There was a task force set up in 2004 in the Eastern District of Virginia. It was informally called the Detainee Abuse Task Force. They investigated charges of CIA misconduct. It was made up of career DOJ prosecutors, not political appointees. And those involved came out and said the federal prosecutors reviewing the CIA misconduct there were seasoned professionals who would not have hesitated to go after these CIA agents if the situation was warranted.
Can I answer?
Sure.
I think we know a lot more now than we did in 2004 about what was done and about the orders under which they did it. And I think that the Attorney General is entitled and obligated to, in light of all these new facts, to take a look at that, regardless of what was decided back in 2004.
The Attorney General looked at the IG report. He looked at the Inspector General report. That's what this task force looked at 5 years ago. The same thing. It's not more information. It's the same document leading to two different decisions, one by career prosecutors and one by political appointees.
On the contrary, there's a lot more information now that is known than was known 5 years ago, and a lot more than, presumably, than that document was able to take into effect. At any rate, that's the determination of the Attorney General, who has more facts than you or I do. And all he has done is to authorize an investigation, a preliminary inquiry, not an investigation, a preliminary inquiry to determine whether there ought to be an investigation. And this preliminary inquiry was handed to a very conservative Republican career official in the Justice Department.
Understood, sir. The point I'm just trying to raise is they already made a decision on this 5 years ago, saying no investigation was warranted. Now this Attorney General says an investigation is warranted. Now in 5 more years, are we going to get a different decision? You see how we need consistency and how some Americans could be concerned. I'll give you the final word, sir.
This Attorney General has said an inquiry to determine whether an investigation is warranted. There is no investigation. It's simply an inquiry into whether there ought to be an investigation. And the fact is that when more facts come out, until the statute of limitations runs, it is always the prerogative and the duty of someone in a prosecutorial position, such as the Attorney General, or in a position to make such decisions, to review and reconsider based on new information, or based, frankly, on their understanding of the law.
Okay. Congressman, thank you so much for coming on with your insights on it. We appreciate you being here.